All right, hi there, everyone. I'm back with the video lectures for this one, and at the very least, I'll give you the outline, if not the whole set of lecture notes. But this way, you should be able to get all the information you need. Again, type these up, handwrite these however you take notes. This is your outline for this evening, and there are several tabs up here I'll click through and talk about, and you feel free to add in the details that you think are relevant. Now that you're more familiar with how quizzes and exams work, of course you'll become more familiar as the semester rounds out, but I am looking for detail, and I'm looking for detail through the breadth of everything. So that is that, and I'll turn here to our outline. We'll just get right into it. So I'm talking about human rights. Uh, this is a kind of a new topic, I guess, in the ways that nuclear weapons is kind of a relatively new topic in global politics. It's not hundreds or thousands of years old. Widespread adherence to universal human rights, or the notion of it, I shouldn't say the practice of widespread adherence to universal human rights, it's a relatively new concept in world history. Excuse me. So the reading you were supposed to have done before you get to this lecture, and if you don't, make sure to go back and do that first. But it points out correctly that prior to the end of World War II, so World War II, remember, ends in 1945, any conception of rights was largely nation-based. So you would have rights as an Englishman, or as an American, or as a Frenchman, or as whoever. But there's no widely accepted sense that individuals had rights by virtue of the fact that they were human. The idea that there were rights that transcended what national governments may have decided to allocate to their people. That's something that was new and different. So what's the deal? Why is it that things change in and around 1945, and we add to the existing concept of nation-based or state-based rights, we add the idea that there are certain global human rights that transcend national borders. And my point here is not that everyone recognizes and accepts these rights, because I know they don't. That's also true at the national level. But my point is that there's the beginning of a widespread recognition that people have rights even if their national governments may not protect them. That those rights do still exist, and that it's a shortcoming of governments that do not. So with that out of the way, what explains this period of change when things are not the same at the end as they were at the beginning? It is largely the manner in which World War II was fought, and some of the particularly horrific events, and among those, of course, has to be counted the Holocaust, the program set up by German Nazis to systemically kill European Jews, and in addition, other groups as well. But the primary thrust is against European Jewry. And in the immediate aftermath of the war, this information was not widely known, but it began to be more widespread as time goes on. And in addition to the Holocaust, a particularly brutal and inhumane campaign, there were the more general war crimes tribunals that were established to try individuals who were part of the Japanese government as well as the German government. and those are respectively the Tokyo War Crimes Tribunal was for certain members of the Japanese government, and the Nuremberg War Crimes Tribunals were for those who had served in the German government. Now, in those war crimes tribunals, one of the common defenses that were offered by those who stood accused was that they were simply doing their jobs. They were members of a government. There's some sort of hierarchy in place, and they were effectively following orders. And the tribunal largely rejected those claims, and in so doing establishes the precedent that national sovereignty did not give governments license to do whatever they wanted within their borders or in other territories that were under their control. The punishment of German and Japanese war criminals was quickly followed up by two important and related documents. So those documents, 1940, well, they both happened in 1948 as it happened. The Universal Declaration of Human Rights is an important one. It is going to join later 1966 two really foundational pieces of international law, which you can see are on the outline. But first things first, this is the Declaration. Now, the Declaration, as the little history here tells us, it was passed by the General Assembly without objection, though there were some abstentions. Some people chose not to vote. But a declaration is just that. It's been declared. It doesn't make it a treaty, say that states are obligated to follow. Now, on the outline, the two international conventions that follow in 1966, now that is international law, and those do represent commitments that states have undertaken. But the Declaration, if you want kind of quick and easy shorthand, I would say that it's more important for the norms it sets, right? And norms constructing appropriate, or what are viewed as appropriate sets of behaviors and inappropriate sets of behaviors do matter, as they do shape expectations about proper conduct. And states do, despite what some claim, states do care about their conduct. They don't seek to be ostracized, to be isolated. So it's not to say that the UDHR is meaningless. That's not true. But it's also, it does not carry with it the weight that something like international law would carry. So it's very long. I'm not going to read it to you. You can see the URL even up on your screen. So you could go ahead and go there if you wanted to, but it's one of the many pages here on the United Nations website. So we have many articles. It's not necessarily brief, but the articles themselves are relatively brief, so it's not a long thing. But again, it is more aspirational than anything being decided. And I suspect before I totally just run away from this, it might be worth slowing down a bit, even though you can read this. And notice that there are, now for those of us who are Americans, or at least familiar with American political history, geez, some of this language here, not all of it, but some of it sounds a whole lot like, geez, some of these key documents from American political history. All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience. That phrase there, they are endowed with, sounds a whole lot like, geez, some passages from the Declaration of Independence. Right? They are endowed with certain unalienable rights, is the language they use, that among these, right, life, liberty, and the pursuit of happiness. Of course, down here in Article 3, everyone has the right to life, liberty, and security of person. Not exactly life, liberty, and pursuit of happiness, but pretty darn close. right? So remember, this declaration is the Declaration of Human Rights, not the Declaration of Independence. But anyways, you could read it if you wanted to. No one held in slavery. Interesting, no one shall be subjected to torture or other cruel, inhuman, or degrading treatment or punishment. I could tell you from other things I do, the 8th Amendment of the United States to the United States Constitution is the one that outlaws the use of cruel and inhumane punishment for crimes. Again, Article 5 is not exactly word for word the same, but it's basically the same idea. And I kind of laugh, especially when Americans, look at these documents and like, oh, how silly. But when you talk to them about the Constitution, including the Bill of Rights to it, a declaration, they get very adamant that these are very important documents and represent big changes for American government. And I don't know that they know how much of it is in these sorts of, this in particular, the Universal Declaration of Human Rights is kind of viewed as the beginning of the international human rights regime, at least going through the United Nations. I'm not sure they're aware of it. But if you were never taught it, I can't fault you for it. But now you are aware of it, and so now if you don't know it, now it is your fault. But yeah, it might be worth a perusal. Again, if this is the last time in your life you ever look at any of this stuff because it's just not your thing, do it right once. And then you can tell yourself you've tried it, and global politics and all that is not for you. And who knows? You never know what you may find. All right. The other thing that happens in 1948, again, it's a big year when it comes to human rights. Now we actually do get a piece of international law. It's not the two 1966 ones. Obviously, those are on covenants on civil and political rights on the one hand, and economic, social, cultural rights on the other. This is the, you can read it, the Convention Against Genocide, okay, or the long end, the Convention on the Prevention and Punishment of the Crime of Genocide. So again, you can read the URL up at the top if you wanted to go find it. This is, again, part of the United Nations. You can read, it's the Office on Genocide Prevention. Yeah, you can see it's. You can see what it is, or at least you're more aware of it. So, and it's been effective since, you can read 1951. So just because it came out in 1948 doesn't mean it went into effect. It took a few years. Now, if you want to know the background to how this got started and the works of a lawyer guy named Raphael Lemkin, then a book I can recommend to you is, it's called, this is the title, A Problem from Hell, and the author is Samantha Power. And if you know who Samantha Powers is, she served in the Obama administration. I believe she eventually made it up to U.S. ambassador to the United Nations. I'm not sure if she went beyond that, but she's an academic by training, but she very much ended up in the policy world. And while her book is mostly about the United States' failure to actually step up and prevent genocides after 1948, the first part of the book is the story of Raphael Lemkin's kind of one-man crusade for years and years and years and years and years to get recognition for this crime, which we had to invent a name for, genocide, and then getting the countries of the world to agree to the Genocide Convention. It was a struggle, and maybe one that we take for granted, but there you go. Some actual international hard law more than just a declaration. All right. So, yeah, in 1966, we get the two kind of big successors. Here, we can get rid of that. To the Universal Declaration of Human Rights. This one, Convention on Civil and Political Rights, was largely championed by the United States because, of course, the reason I gave you all that history some time ago was so that you would have, you should know what's going on in 1966 as well as 1948. You should understand kind of the global situation, to put it a bit vaguely, but it's the Cold War. 1966 as a year. I mean, of course, Vietnam is getting more intense, but generally, it's the Cold War. And so, as with so many other things during the Cold War, even something like human rights treaties become part of the East-West conflict. The United States was more interested in pushing the Convention on Civil and Political Rights because it was a convenient tool to try to embarrass the Soviet Union and a number of its allies who could not or would not make available the kinds of freedoms called for in the Convention on Civil and Political Rights. Those are sometimes referred to, I don't know that I love the name, but anyways, because Minks and others use it, they'll talk about first generation human rights, civil and political rights. And some of the things I looked at with you in the Universal Declaration, you have freedom of religion, of conscience, of speech, protections for individual persons, those sorts of rights. The Soviet Union and others, wasn't just the Soviet Union and its allies, but others also signed on to the Convention on Economic, Social, and Cultural Rights, and this is what's sometimes referred to as your second generation human rights. And the Soviet Union preferred to talk about these because they were relatively better at providing them, right? Relatively better than providing civil and political rights to their people. And they already, freedom of speech is great, but it doesn't mean too much if you don't have a job and you're living out on the streets. Yeah, you can say whatever you want, but a lot of people probably would prefer to have shelter, food, secure income, retirement, education. So those are the priorities of what's sometimes called the Second World. That was kind of the Soviet Union and its allies, but again, not exclusively. Right? And other left-leaning states, even democracies, came to endorse the Convention on Economic, Social, and Cultural Rights because they agreed with it. And of course, members of the non-aligned movement could agree with those things as well. So, and you should know all those terms because you read about them earlier in the course. You can't leave any of that stuff in your wake as you speed on through this course on global politics. So that's another big development. It takes 10 years for those to be operative to go into effect, but they do eventually. Very conveniently on the bicentennial of the United States Declaration of Independence, right? 10 years after this, 1976. All right. That is what I want to say about those early human rights treaties. Okay, so the next point here, closely related to the idea of human rights, international human rights, and international human rights law is the idea of humanitarian law. They are closely related, but they are also different. Human rights law is meant to protect people's rights in normal times, so normal non-emergency. So we're not talking about, say, in times of widespread armed conflict or perhaps a famine or some sort of natural disaster, which might produce a kind of temporary emergency. The idea of human rights is that national governments are expected to be the guarantors of basic human rights protection. Humanitarian law is supposed to regulate the conduct of combatants fighting a war. Among other things, it outlines acceptable targets for violence, acceptable uses of force, and outlines some of the standards for the care of the wounded and the shipwrecked. I believe, let's see if my tabs are correct. Yeah! Alright, so 1949, sometimes you'll hear people reference the Geneva Conventions. Well, this is them. And they're quite lengthy, so we're not going to run through all of them, but the Geneva Conventions of 1949, and there are several of them. This one here is what are we talking about? Relative treatment of prisoners of war. And you can see what they are. I mean, when I said that this is long, I meant that this is really, really long. Which I don't expect any of you to read, though you could pause and type in the URL if it really mattered to you. But we see the rise of new humanitarian laws and humanitarian standards also in the wake, in the shock of World War II. If you want kind of, I guess, the synopsis, you can turn to the International Committee of the Red Cross. They do some things very well, other things maybe not quite as well. However, it's a very good first stop. So if you want to see the international humanitarian law treaties, now customary international law, as you can see, doesn't come out of a treaty, but it comes, think of it as a past practice. And they keep a collection of what they view is customary international law. Anyways, this is kind of esoteric stuff. Unless you're really looking for it, you're probably not going to find it. This is the more standard treaties and so forth that regulate methods of warfare. And you could peruse this if you wanted. I strongly encourage you to do it, even if it's kind of just aimless wandering on your part. I still think it's worth doing. I'm taking a bit of risk here. I don't know what we're going to find with this. Still not even sure what that was, but there are 161 rules of customary international. I had no idea that was a thing. Maybe we're stuck in a loop. Oh my goodness. Sure. Oh my goodness. So this is all the stuff. So if it's customary international humanitarian law, it's not written down in treaties. These are just practices that have developed over time, which the Committee of the Red Cross argues is still binding. This is actually really interesting. I did not know about. I did not know I was going to find that, but there it is. And I'm guessing that this is probably, so that's a little bit more fixed. So they have language going back to 1904, and you're literate, but it's the Hague Convention on hospital ships, right? So we have 1949. We have several Geneva Conventions in 1949. Great. And then we have these other humanitarian law treaties. So those are those. And again, remember, humanitarian law is largely the laws that apply during periods of armed conflict. And so they're not expected to be in force all the time. We also got to remember that international humanitarian law was negotiated by states, and it was done so for their benefit. And as always, it's states who are the ones who are held to the standards that are outlined in those treaties that I just took a quick trip through with all of you. As you may recall from a previous lecture and readings, non-state actors, right? We talked about terrorists, we talked about civil war and ethnic conflict, are frequently among the participants in civil wars and in ethnic conflicts. Those armed non-state actors are not parties to international law in the same way that states are. However, there is one international non-governmental organization, which we talked about NGOs. Well, I gave you the lecture notes there on NGOs in the previous lecture. One NGO, Geneva Call, has been trying to get armed non-state actors to actually abide by some basic humanitarian rules. So I think that's here. It is Geneva Call. I remember I found out about this group. I think I was in graduate school. I'd never heard of them before that as an undergrad, even though I studied international relations. But yeah, I mean, that is an accomplishment. Some more than 129 state actors have basically signed on to some basic humanitarian law protections. Kurdish demobilization. Okay, so we're going back in time with those. So I guess the stuff at the top is, yeah, Polisario Front. I believe that's in Western Sahara. Polisario rebels, I believe. Protecting healthcare. Anyways, it's worth knowing about. It's a really strange development. Geneva Call in and of itself is a non-governmental organization partnering with other non-governmental entities, these armed non-state actors, right? They're not part of state militaries. To get them to agree to some of the standards of fighting war that states have negotiated. I don't know, maybe that's not as impressive and interesting to others as it is to me. It seems a bit odd and at the same time interesting. So, sometimes that happens. I'm not going to make any more of it than it is, but now you're aware of it. The work of Geneva Call. All right, I'm going to turn to next is the role of, okay, we know about IGOs, but their roles specifically when it comes to human rights. All right, so the role of IGO, specifically really the UN and its affiliated bodies and the promotion of human rights. So the UN does play a leading role among all intergovernmental organizations in the advance and protection of human rights. In addition to peace and development, human rights is the third pillar of the United Nations system. It's based on pacific resolution of disputes, what we would probably call economic development, and protection of human rights. And it's enshrined in the UN Charter in Article 55. It calls for universal respect and observance of human rights and fundamental freedoms. More concretely, how it does that is through many of the associated organs, which you learned about just a few lectures ago, the organs of the United Nations. So within the Security Council, there's a role to play for protection of human rights. Most complex peacekeeping operations today, and I talked about and you read about in Mengst what those were, they have post-conflict human rights monitoring as part of their mandate. United Nations Security Council can also authorize sanctions as well as the use of force in cases of egregious violations of human rights. And it's worth remembering that it's not just theoretical, that practically this has happened. The Security Council imposed sanctions against the white minority apartheid regime in South Africa in the 1980s. And in so doing, it made it clear that it found the domestic political system in South Africa a threat to international peace and security. United Nations General Assembly, sometimes referred to again as a kind of global Senate, because all member states are represented and have an equal number of representatives. In the General Assembly, human rights constitutes a significant part of what it does. We do have to remember the General Assembly has its limitations, and that its resolutions are only recommendations, yet about 1/3 of the General Assembly's resolutions address human rights issues. The Office of the Secretary General, or the Secretariat of the United Nations. The Secretary General's office periodically reports on specific human rights concerns. An example would be in 2015, the Secretary General's office published a report on the human rights situation in Iran. One of the specialized agencies, the Office of the High Commissioner for Human Rights. It's pretty much in the name. There's actually, I think I had a tab reserved for this. Actually, it looks like we have two tabs. But here you can see the Office of the High Commissioner for Human Rights. There are, all of these are the titles of different contemporary human rights issues, which I have no hope of getting through in one lecture. I mean, some of these topics take up the majority of one of our lectures at some point, but as you can see, there are a lot of human rights issues that it is tasked with covering. If you want to know how it works, right, this is how it works. We can see that these are several of the countries of concern for the human right. Oh, I'm sorry. This is for the human rights. I jumped forward a bit there. I'll take a step back. I'll pick up with our outline here. The next part is the Human Rights Commission. All right. So the Human Rights Council. There are some parallels between the UN Human Rights Council and the next institution I'm going to talk about, which is the International Criminal Court. They both attempt in their own way to end impunity, which is a kind of fancy way of saying non-prosecution of human rights violators. The Human Rights Council doesn't have the ability, though, to levy any sort of sanctions against offenders. What the Human Rights Council can do, and it does it, is that it reports periodically on all countries' human rights practices. This is what's known as Universal Periodic Review. You're going to hear this term again when I get to economic intergovernmental organizations. It's about a month out in this course, but it's almost exactly like what the World Trade Organization does with monitoring its members' trade practices, except the Human Rights Council is doing it for the human rights practices of all of its members. The purpose of something like Universal Periodic Review of all members is to have countries warned in advance that their human rights practices are being monitored, will be reported on, and the world will more than likely know how those countries have done, whether they've done better or worse, and that in and of itself may deter states from committing egregious violations of human rights. All right, for you here, these are the specific commissions of inquiry. You can read commissions on human rights, fact-finding missions, and other investigations. It's always a bit of a risk to open a link while doing the video, but there we go. So this is the special fact-finding mission. This is one of the things the Human Rights Council can do beyond Universal Periodic Review, and this is what they were told they could do. I guess I can highlight most of it. Find out who it was. Let's see what else. Burundi. Looks like a commission of inquiry. It is. This is what it was supposed. This is what it was told it was going to do. All these things under a mandate. Frequently, you'll read or hear about the mandate given to a peacekeeping operation by the Security Council. Well, this is slightly different. It comes from the Human Rights Council, and it's specifically given to the Commission of Inquiry in Burundi. And you see how it goes. I mean, again, you could read the URL up here, and you could click on these if you wanted to. I'm just a little interested. That's all. All right, let's stay on task. Let me stay on task. We did Human Rights Council, so we're up to International Criminal Court, the ICC. I think I have two. I do have 2 tabs for you. All right. So, in the previous reading and lecture, sorry, not, this is not Monday's lecture, but the International Court of Justice was introduced. And that was largely, and still is largely, about peacefully resolving disputes between and among countries. It's largely about state responsibility and what states can do. It does not, as a rule, go after individuals. International Criminal Court does. And again, it is a good deal newer than the older International Court of Justice. And the ICC has greater authority than even the Human Rights Council, which I just talked about. But the ICC does have the ability to prosecute and, if convicted, imprison people who have broken various international laws. The idea here is to put even more teeth, or really coercion, right? The threat of imprisonment to state leaders or government functionaries who may consider violating human rights. They may be able to escape prosecution in their own country, but that is no guarantee that they'll be able to escape prosecution by this international body, which, rather than assigning state obligations, is going after individuals for things that they have done. And national sovereignty is no shield or no defense that is likely going to fly at the International Criminal Court. There is some confusion on the way the body works. Particularly, it seems so here in the United States, where it seems like a good deal of distrust of intergovernmental organizations. Even as I've told you earlier, a lot of these were created at the behest of the United States and were designed to further American foreign policy goals. The United States does not usually set up international organizations and then continue to support them if they don't serve American foreign policy interests. And so we ought to keep that in mind. But there still seems to be some skepticism about these organizations. Now, the United States is not a member of the International Criminal Court, but how it works very broadly is that if a state ratifies what's known as the Rome Statute, that's the international convention that created the ICC, they're supposed to comply with requests from ICC prosecutors to turn over individuals who are believed to have committed certain crimes that fall within the ICC's jurisdiction. Again, I'm talking fairly broadly here, as this is the lecture. Try to leave some of the more detailed stuff for reading. But broad brushstrokes here, the way the ICC works is that states are presumed to be the ones who are going after their own human rights violators. The ICC acts as a kind of backstop to national level prosecution and only steps in cases where states are unwilling or unable to do so. It doesn't have its own police authority, right? It hasn't solved the international anarchy problem that intergovernmental organizations, even the UN, have, which is that there's no international police force that's there to enforce international law. So the ICC still relies on states, on governments, to abide by the terms of the convention and help make the ICC work. If states aren't willing to comply and to assist the ICC, then it's not going to fulfill its function. So it is not independent of states. It very much relies on them to turn over individuals for prosecution, and states who have ratified the Rome Statute, if their leaders are wanted for prosecution by the ICC, are supposed to turn them over. If individuals who are wanted by the ICC but are in a country that hasn't ratified the Rome Statute, but they then travel to a state that has ratified the Rome Statute and is part of the ICC, they're supposed to detain them and turn them over to the ICC for prosecution. So, as I mentioned, it is newer. It's certainly a kind of criminal justice assigning of individual responsibility for individual actions approach to things, whereas the ICJ was more about peacefully resolving disputes before they resort to war. This is different than that. The ICC and the ICJ, while they may have international court in their names, they have different targets. Broadly, they are trying to further respect and abidance by international law, but for different parties and in different ways. All right. Moving right along, I think it'll probably just be a little bit easier if I throw some of these links in this document and then just give you the outline. There were two long articles here. This one's from the International Committee of the Red Cross and the Carnegie Council. It looks like I was going to give those to you anyways. This link at the library actually did not seem to work when I tried it. So I'll tell you what, at the end of this, when I'm posting this and all that, I'll throw these links down here in case you wanted to click on anything and follow it through, and you'll be able to access that through the YouTube video when I throw the link from this in there. Yeah, these are the arguments, the Asian values debate, and so on, but we're not going to do those right now. All right, what are the challenges for human rights? What's going on today? All right. First point, it's the Security Council. It's not just the Security Council. I mean, it's the Security Council, it's the Human Rights Council, it's the International Criminal Court, it's also the International Court of Justice. All of them lack true independence to do whatever they want. They all still rely on state governments to do what it is that those intergovernmental organizations want to do. And if states aren't willing to allocate resources to do it, it's not going to happen. And there are a lot of things that compete with international human rights concerns, a lot of them related to national defense. And so if states don't make a priority of human rights, it's very hard for the intergovernmental organizations to do more than what they're given by states. Second point, nothing that new. I mean, the second point there, so is states do not have to comply with ICC proceedings. It's also true of the ICJ in its own non-human rights context. And if you're powerful enough, you can just kind of ignore the ICC, which gets into the third point as well. But just before we leave the second point, this is a fundamental problem of international law. I mean, it's created by states usually to serve state interests, so there is why international law is frequently followed. Certainly a realist could appreciate that, is because what's known as international law is really just a reflection of state interests, so of course states would do that. And so if ICC proceedings and prosecutions are not automatic, but they only advance against those who are weaker states and can't really afford to escape prosecution, then the ICC begins to look like a tool of the great powers to be wielded against those who are not so great powers. All right, the third point is a distinct point, though, and that is that a number of the great powers today themselves, the United States, China, Russia, a number of others, have a blemished record when it comes to human rights. We've been far from perfect. The United States got a number, or dealt itself, in many cases, a number of black eyes in the early 2000s. Revelations about enhanced interrogation techniques, torture, cruel and inhumane treatment of detainees, as well as a number of cases of mass killing of civilians. And I'm not talking about the accidental kind, where a so-called smart bomb was supposed to hit a target and it hit a different target and killed a lot of civilians. I'm talking about the purposeful mass killing of civilians related to a number of United States interventions in what we refer to as the Middle East and also in Central Asia, among other places. And of course, that's just the stuff from the War on Terror, the era of the War on Terror, to say nothing of past atrocities committed by the United States and others. And so when the great powers themselves seem to be violating human rights norms and treaty commitments, it makes it harder for intergovernmental organizations, for non-governmental organizations that are trying to enforce greater adherence and protection for human rights to do so, because clearly if the great powers don't think it's a priority, it's harder to get others to go along. If the great powers make it clear through a sustained commitment to the rest of the world, this is something that they're willing to put scarce resources into and possibly go after those who don't comply, then it's something that other states who may not care as much begin to start to care about. This is not an exhaustive list, but this is another issue here, the cultural relativism as an obstacle to human rights. And there are different guises of this. It doesn't just come in any one particular form. But there is this argument that it's out there, it's in the world. I hear it in different forms, even on our campus. But the argument goes something like this. Well, Universal Declaration of Human Rights, the Genocide Convention, the Convention on Civil and Political Rights, Convention on Economic, Social, and Cultural Rights. Oh, by the way, all those other conventions you read about in Mingst et al., all right, there are conventions against torture, the Convention on the Elimination of All Forms of Discrimination Against Women, the Convention on the Rights of the Child, all those things, that the charge is that those are largely Western conception of human rights. That the idea to respect those rights grew out of a particular history. Of course, culture is embedded in history and vice versa, but the argument here is that the values that might make sense in the West or in the United States may be fine in those societies, but that they're not as applicable elsewhere. And so one manifestation of this is what's known as the Asian values argument, which had been advanced by a number of folks, including a former leader of Singapore, and again, among others, so he wasn't the only one saying this. But the argument, the Asian values argument, went something like this. Well, all right, individual rights, limited government, all right, that makes sense perhaps in your context because of your history and culture. But the argument goes, in Asia, different history, different values, different culture, And there, the priority was not on the individual, but on the well-being of the group, and the kind of individual rights and the freedom to associate and speak your mind, all that division. Those were not priorities of a number of Asian societies, and so instead, what those values were the well-being of the group, economic development, providing for the group, those kinds of things. And so it required actually crackdowns on a lot of the core human rights that the West would consider human rights. But the excuse was, well, it's kind of for the greater good that we do these things. I'm sure the folks who make the Asian values arguments wouldn't necessarily agree with how I've summarized it, but it's my summary. And it's that kind of folk wisdom, which is like if you have a little bit of knowledge, then that argument begins to make sense. If you have a good deal more knowledge, hopefully you understand why the Asian values arguments and other artifacts of cultural relativism fall short of the mark. The Universal Declaration of Human Rights is not a Western document, unless the West goes on to include pretty much the entire world. I mean, the Universal Declaration itself was vetted by individuals, groups from all around the world, a variety of faiths, cultures, geographies. Obviously, they have their all attendant histories, and taking all of that into account, that led to the crafting of the Universal Declaration of Human Rights, as well as the International Covenant on Civil and Political Rights and on economic, social, and cultural rights. Those were informed not just by leaders in Washington, D.C., and London, and Paris, and maybe Moscow, but by leaders from around the world. It was a collective enterprise. And the states who have joined them have agreed to them, right? It's international law. Even if one were to accept the wrong assumption, it's incorrect as a matter of fact that the key human rights documents are kind of American or Western creations. Once other states, not of the West, sign on to them, they've taken on the obligation for themselves, and it's reasonable to expect them to live up to it. It's not really my job to fully gut the cultural relativist argument. You can do that, I believe, still in some philosophy classes here on campus. But this is another manifestation of that idea of cultural relativism, which you might learn in a philosophy course offered here on campus. This actually is its own last point, so if that wasn't clear. This one, I think there's actually a good deal to this lack of state capacity, and I've left some of the text here in the notes, but I think there's actually something to this. I'm always a little amazed in the United States, because it's the society I'm most familiar with, at the kind of ignorance about how expensive civil and political rights are, and how incomplete they are, even in the United States. So back up to these two documents: Convention on Civil and Political Rights versus the Convention on Economic, Social, and Cultural Rights. The United States has signed and ratified this. We have not ratified the other one. This one we have not ratified. One of the reasons, the kind of rhetoric in the States is that, well, this aligns more with the Constitution, the Bill of Rights to the Constitution, and some of the concerns that were expressed in the time of America's founding. And that these are, not as extravagant to spend on as these things. It may be true that in total they're less, although I'm not sure that we've actually done this always as well as we think, but supposing that we have, we spend a lot of money in order to get civil and political rights correct. What am I talking about? So if you decide that freedom of speech is going to be a thing, freedom of conscience, freedom of religion, freedom of assembly, just to name a few of the rights that states are expected to protect. That means you need to have a system in place that anytime one of those rights is violated, some sort of redress can be given. So you got to have a system of courts. Courts require, among other things, trained judges, competent prosecutors and attorneys. If you're going to use jury trials, you're going to need to have juries with at least the minimum knowledge to make informed decisions. You're going to need, the laws on the books are actually the easy part. Getting a legislature, even in a developing country, to pass a law changing language is easy. The hard part is enforcement. You have to have a competent police force that's willing to enforce these laws and provide these protections. You may also need to have the requisite civil law in place to impose fines and so forth on those who violate these rights to speech or whatever the right is that's being violated. That requires a tremendous amount of state capacity. I mean, this is what developing countries are lacking. And the idea that the United States hasn't had those, even going back to the late 1700s in the United States, many towns, they might have a church, but they're also likely going to have a courthouse, or they're going to use some other public space, a tavern, and that's going to be their courthouse. You got to have those kind of institutions that are ready to go. And even in the United States, it's taken centuries to develop those. And as we see, there are still grave miscarriages of justice, even with those. But, civil and political rights are tremendously expensive to get right, and they're even imperfect when you do. If you then also expect countries to provide economic, social, and cultural rights, and where this money is going to come from is unclear. So lack of state capacity, whether it be on the civil and political rights end or it be on the economic and social rights end, developing countries are developing because they don't have capital, and they need capital to protect these rights. Anyways, this to me is possibly one of the more compelling explanations for why we don't see better protections of human rights. In general, human rights are more well protected in richer countries. Therefore, one expects as other countries grow richer, their protections for human rights ought to improve if they're growing richer. All right, so we took this out, so we don't need this anymore. Okay, those are kind of the big challenges of today. And so if one reads, the international section of the New York Times or Economist or Foreign Affairs, it says, hey, look, we have all these violations of human rights and non-enforcement of international law. Why? Well, now hopefully you have a greater appreciation of the why. And if you understand the why, you should also probably be able to think about solutions. And this one, the solution might be in economic development, which is one of the later topics that we get into. And so in addition to just, providing more resources to help people survive, live longer lives, so on, it's also quite possibly going to improve their capacity to protect human rights, a kind of knock-on effect of economic growth or economic development. But I've gone on long enough for this, so I'm going to cut it here, and yeah, I'm going to cut it here. If you have questions, as always, there are office hours to go to. Reach out to me. When this is going up, you will have found out about Exam 2 going out, Quiz 4. So work on those on your own pace. And yeah, that'll be it. All right, thanks a lot, folks.